Here are 5 contracts that every HR team needs in order to protect their organization. And by the way, if you're curious, you can download these for free right down. Now, before we get started, a quick note that nothing we're about to talk about today here is legal advice. This is all for general information only. There are 1.5 million different reasons why these documents may need to change in order to fit your situation. So remember, talk to qualified legal counsel before you issue or distribute any of these sorts of documents. Let's talk about number 1, a separation agreement. Everybody talks about this all the time. When somebody leaves a job or when they're about to get fired, they complain about, oh my God, I didn't get any severance, or yeah, it sucked, but I got severance on the way out, right? So a severance agreement is one of those things that you're gonna wanna have in your arsenal whenever it's time to get rid of an employee and you decide, hey, maybe we wanna give them some money on the way out for any different reasons. So for those of you who don't know, a severance agreement, or a separation agreement as it's often called, is that agreement that an employee signs on their way out from employment with the company, and that it gives them some money, right, to ease the cushion out after, now they're losing some income. Usually we're talking about giving an employee some amount, weeks or months of their salary or of their pay in exchange for a release of claims and a bunch of other things. The big thing that employers are really in this for is the release of claims. Now, the release of claims is just something that says, I, employee, agree not to sue you, employer, for basically anything that has to do with my employment with the company in exchange for getting some cash on the way out, right? So this is really, really what's important for employers, because it's what gives you some degree of certainty that, yeah, when this employee is gone, if they were problematic or if there were problems with their employment relationship, you have some security, some certainty that you are not going to have a claim on your desk in the week right after they're gone. But that's not all that these separation agreements do. A lot of other things buried in there. One of the most important things for employers is confidentiality rights. So a lot of these separation agreements will say, I, employee, agree not to talk about the financial terms of the separation agreement. Or it may say, I may not even talk about any of the terms of this agreement. Or I may not talk about the circumstances of my termination. You can draft this however you'd like. Know that in different states, different things, you can keep an employee quiet about certain things and others not. Confidentiality rights are under fire because a lot of legislatures are catching on that employers are trying to silence employees about things that happen in the workplace that you want people to speak out about. That doesn't apply to everything, but just know that you got to check your confidentiality rules in any given state before you put this out there, right? And then finally, on that release of claims, although it's very, very broad release of claims, it is not entirely foolproof. At the end of the day, even if an employee agrees not to sue you, that doesn't limit their right and their ability to talk to a government body like the EEOC, the Department of Labor, National Labor Relations Board, the SEC, any number of government agencies who may have an interest in knowing what's going on in a workplace. You cannot stop the employee from going to a government agency to make a complaint or to participate in an investigation that they are handling. Now let's talk about employee NDAs. An NDA is something that you hear about all the time. It's this really kind of popularized term. An NDA, all it really is a confidentiality agreement. An agreement that says, hey, in the course of your employment, you are going to receive some sort of information, or you're going to have access to see certain things that maybe you as the employer don't want to get out there. Maybe something about the nature of your business, maybe things about your clients and your customers, what have you. You can't keep an employee from being quiet about anything and everything. There's a lot of federal labor rights that are involved here, and an employee does have the right to nevertheless talk about terms and conditions of their employment, workplace, hazards, all that sort of stuff. But for the most part, what we've included here for you is a very, very simple template for an employee NDA that says, hey, employee, as part of your employment, you're going to receive some information here. Please just keep it confidential in exchange for your employment. Now, one thing that's really important to know here is that a lot of different states have different rules on the books regarding whether you can give this to a current employee for free. These are rules about contract law, essentially, that say if an employee already has the job and they're not getting anything new by signing this for you, that you have to give them a little something extra. That can be, some extra cash, some extra PTO, something of value, but you got to give them something. Now remember, that's really only for people who are currently employed with the company and you're rolling this out. It's not necessarily for people who are coming in as a new hire. Now let's talk about a proprietary information and inventions assignment agreement, which is, in a nutshell, an employee NDA but on steroids. So what a proprietary information and inventions assignment agreement does is it gives stricter confidentiality rights. It beefs up the definition of what is confidential information. It also often talks about what might constitute a trade secret that the employee may come into contact. Importantly, it also assigns inventions to the company. So for employees who will be developing really anything during the course of their employment, this says, I, employee, will give to you, employer, the intellectual property rights to whatever it is that I develop, right? And so that can be really a lot of things. That can be concrete objects. Maybe if you have a team of engineers, it could be things that are a little bit less concrete. So maybe you have software developers who are creating software, or coders, or maybe you have marketing folks and they are creating graphic designs or formulas or whatever. Whatever these things are that the employees may be developing, they say that they are giving you the rights to them because they created them in the course of their employment. Now, a lot of states are cracking down on really, really broad inventions assignments agreements. And so they say anything that an employee develops on their own time and on their own dime, so without company resources, maybe just in the dead of night on their own, the company cannot require them to assign the IP to the company just because they did it while they were employed by the company. Make sure you have those really cleanly laid out in the exhibit accompanying the agreement so that you know up front what exactly might we be talking about that the employee has developed on their own time, so that later there isn't a surprise with an employee saying, hey, I made this and this actually belongs to me. Next, let's talk about arbitration agreements. You may have heard what arbitration is. Arbitration is really just a private alternative to court. It is an alternative dispute resolution forum where folks agree to say, hey, if we have a claim between one another, we're not going to take this to a public court. We're actually just going to take this to a private arbitrator, often a retired judge or another lawyer, and we're going to do this on our own, essentially, right? The main draw to arbitration is that it is sometimes cheaper than litigation, or at least that's kind of the prevailing wisdom about it, but it not always is. So in arbitration, unlike a judge, you got to pay for the arbitrator's time, who usually charges an hourly fee just like an attorney might. So that means, and in employment cases, employers have to pay almost all of the costs here. You cannot require an employee to basically cover their part of the fee for the arbitrator, because then otherwise you've almost blocked their access to justice, because most employees just can't afford the amount of time and money that it costs to hire an arbitrator. Nevertheless, a lot of employers choose to maintain an arbitration program anyway because they prefer the confidentiality that comes with it. They also prefer how much more streamlined it often is. Arbitration in many ways is very similar to a court process, but one thing that's really important to keep in mind about arbitration is that although the claims that an employee will have to arbitrate with this are very, very broad, there have been laws going into the books over the last couple of years that prohibit an employer from requiring an employee to arbitrate certain claims. The most famous of those is claims about sexual harassment and sexual assault. Many employers were maintaining arbitration agreements that essentially forced employees to not go public with their sexual harassment and assault stories that happened at work. You might remember this from the Me Too movement. And so although you can have arbitration of a lot of claims, just know that you need to have carve-outs built in for things like sexual assault and harassment, and then some other things that different states sprinkle in along the way. And then finally, let's talk about one of these templates that's an addendum to an employment agreement. So employment agreements aren't always required for most types of employees, and often I don't recommend them, but you may have employment agreements with a lot of your employees. And as we all know, the relationship changes. What you agreed upon when the employee started or what they got in their offer letter isn't always what's going to stick as they come in. Maybe you negotiate additional compensation, maybe you negotiate additional responsibilities, more PTO, whatever the situation may be. And so sometimes you may need to make a change to this. And so we've included an addendum to an employment agreement here for you so that you can make those changes and formalize them in a way that still keeps the rest of the contract intact. So it's important to remember that this addendum to the employment agreement is in and of itself a contract. And so it requires some consideration. Often that's going to be built in based on what it is that you're negotiating or the employee is looking to change. But it's also really important that when you make this addendum, you are not messing up a lot of what existed in the prior contract. So it's important that you're only changing the specified things that you're looking to change and making it really clear that basically everything else stays the same. And if you need help with any of these kinds of things, the link to book a consultation is down below. Thanks for watching.